Picture a vast, sun-scorched landscape in southeastern Arizona, where the horizon stretches unbroken and the silence is broken only by the whisper of wind through mesquite. On the Lazy Bee Ranch, a young Sandra Day rose before dawn, her small hands learning to mend fences, brand cattle, and read the subtle language of the desert. Her parents, Harry and Ada May Day, ran the 198,000-acre spread with grit and pragmatism, and they expected the same from their daughter. From the age of 8, Sandra drove a pickup truck across the rutted pastures, and by her teens she could shoot a rifle and ride a horse, as well as any ranch hand. This was no romantic frontier fantasy. It was a life of relentless work, where a broken windmill or a drought could mean disaster, and where self-reliance was not a virtue but a necessity. The Lazy Bee taught her that problems were to be solved, not bemoaned, and that cooperation with the land and the people on it was the only way to survive. Isolation shaped her childhood in profound ways. The nearest town, Lordsburg, New Mexico, was a long drive away, and her early education came from her mother, who taught her to read by the light of a kerosene lamp. At age 6, she was sent to live with her grandmother in El Paso to attend a private school, a separation that was painful but typical for ranch children. She excelled academically, skipping 2 grades, and graduated from high school at 16. The young Sandra was quiet, observant, and fiercely determined, traits forged by the solitude of the ranch and the high expectations of her parents. She learned that a woman could be both tough and gracious, a balance her mother modeled daily as she managed the ranch's accounts, cooked for the cowboys, and still found time to read literature and play the piano. These early lessons in capability and composure would become the bedrock of her character. When she arrived at Stanford University in 1946, the campus was a world away from the Lazy Bee. Palo Alto's gentle climate and Spanish colonial architecture were a stark contrast to the harsh beauty of the desert, but Sandra adapted with the same quiet confidence she had learned on the ranch. She majored in economics, a practical choice that reflected her family's emphasis on tangible skills, and she graduated magna cum laude in just 3 years. The post-war university was brimming with veterans on the GI Bill, and women were a distinct minority in most fields outside of teaching or nursing. Yet Sandra moved through the sandstone arcades and red-tiled roofs of Stanford with a sense of purpose that set her apart. She was not there to find a husband or to pass time. She was there to build a foundation for a life of meaningful work. Stanford Law School in 1950 was an even more rarefied and male-dominated environment. In a class of 102 students, only 4 were women, and the faculty made no secret of their skepticism. One professor reportedly asked the female students why they were taking spots that belonged to men. Sandra did not argue, she simply outperformed. She served on the Stanford Law Review, a mark of academic distinction, and she formed a close friendship with a fellow student named William Rehnquist, who would later serve alongside her on the Supreme Court. The law library became her second home, its quiet halls and the scent of old books a refuge where she honed the analytical skills that would define her career. She learned to dissect arguments, to find the precise point of contention, and to build a case brick by logical brick. Her most important meeting at Stanford, however, was not with a professor or a future Chief Justice, but with a charming and brilliant classmate named John O'Connor. They met while proofreading articles for the Law Review, and their connection was immediate and deep. John shared her Western roots and her practical approach to life, and he admired her intellect without reservation. They married in 1952, a partnership that would sustain her through decades of public scrutiny. For their honeymoon, they drove through the Arizona desert, and John got his first taste of the Lazy Bee's rugged reality. The marriage was a union of equals, a concept that was still radical in many circles, and it gave Sandra a stable base from which to launch a career that would shatter glass ceilings. Despite her stellar credentials, a degree from one of the nation's top law schools, Law Review, and a sharp legal mind, the job market of the 1950s had little use for a female lawyer. Firms in California and Arizona refused to even interview her, offering positions as a legal secretary instead. The rejection was galling, but it did not break her spirit. She and John settled in Phoenix, where she hung a shingle and took whatever work came her way, often for no fee. She handled small cases, built a reputation for thoroughness, and waited for the world to catch up to her abilities. The lazy bee had taught her patience and persistence, and she applied those lessons now. The desert does not reward haste, it rewards endurance. Looking back on those formative years, one sees a clear arc from the isolated ranch to the hallowed halls of Stanford. The girl who learned to read by lamplight, who drove a truck before she was 10, and who could calculate the carrying capacity of a pasture as easily as she could analyze a legal precedent, was uniquely prepared for the obstacles ahead. Her childhood had not been easy, but it had been instructive. It taught her that limitations are often illusions, that hard work is the great equalizer, and that a calm, steady hand can accomplish more than a clenched fist. These were the gifts of the lazy bee, and she carried them with her into every courtroom and every chamber she would later enter. The morning sun cast long shadows across downtown Phoenix as Sandra Day O'Connor walked into yet another law office, her resume in hand and her hopes carefully guarded. It was 1952, and the legal profession had no template for a woman who wanted to be more than a secretary. Firm after firm turned her away, some politely, others with blunt condescension. One offered her a job as a legal assistant, suggesting she would be good at typing. She declined. Instead, she found a small, dusty office in a suburban shopping center and opened her own practice, sharing space with a real estate agent. The rent was cheap, the clients were few, and the work was often pro bono, but she was practicing law on her own terms. She handled divorces, wills, and small business disputes, slowly building a reputation for meticulous preparation and unflappable calm. The lessons of the lazy bee served her well. You do the work that is in front of you, and you do it well, regardless of the reward. Her life was not all struggle, however. John O'Connor had joined a prominent Phoenix law firm, and the couple soon started a family, welcoming 3 sons over the next decade. Sandra stepped back from full-time practice to raise her children, but she did not retreat from public life. She volunteered with the Junior League, served on local boards, and became a precinct committeewoman for the Republican Party. These activities were considered appropriate for a lawyer's wife, but Sandra approached them with the same intensity she had brought to Stanford. She studied zoning laws, tax codes, and school district policies, mastering the minutiae of local governance. Her intelligence and work ethic were impossible to ignore, and in 1965, the Arizona Attorney General asked her to serve as an assistant attorney general. It was a part-time position, but it put her back inside a courtroom, arguing cases before the state Supreme Court. The rust quickly fell away, and she discovered that she loved the intellectual combat of appellate law. In 1969, a state Senate seat opened up in her district, and O'Connor decided to run. It was a bold move for a woman with 3 young sons, but she had never been one to wait for permission. She campaigned on a platform of fiscal responsibility and government reform, knocking on doors and speaking at Rotary clubs with a direct, unpretentious style. She won the election and became one of only 2 women in the 30-member Arizona Senate. The Capitol building in Phoenix, with its copper dome and cactus gardens, was a world of cigar smoke and backroom deals, but O'Connor navigated it with the same composure she had learned on the ranch. She did not try to out her male colleagues. She outworked them, mastering the state budget and forging alliances across party lines. Her colleagues respected her not because she demanded it, but because she earned it. Her rise was swift. In 1972, after just 3 years in the Senate, she was elected majority leader, becoming the first woman in American history to hold such a position in any state legislature. It was a remarkable achievement, not only because of her gender, but because of her style. She led with a quiet, pragmatic authority, focusing on consensus rather than confrontation. She reorganized the Senate's committee system to make it more efficient, and she pushed through complex legislation on water rights and education funding. The job required late nights and weekends away from her family, a sacrifice that weighed on her, But she believed deeply in the value of public service. She often said that government was not an abstraction, it was the mechanism by which a community solved its shared problems. Her time in the Senate also revealed a judicial temperament that would later define her Supreme Court career. She was a conservative, but not an ideologue. She believed in limited government and individual responsibility, but she also understood that laws had to work in the real world, for real people. She once told a reporter that she tried to approach each issue by asking, "What is the fair thing to do?" It was a simple question, but it cut through the partisan rhetoric that often paralyzed the legislature. Her ability to see multiple sides of an issue, a skill she attributed to her ranch upbringing where a problem could have many solutions, made her a trusted broker. Even her political opponents admired her integrity and her refusal to engage in personal attacks. In 1974, O'Connor left the Senate to run for a judgeship on the Maricopa County Superior Court, a move that puzzled some of her political allies. Why leave a position of power for a trial court bench? But she had always been drawn to the law itself, to the careful application of rules to facts, and she missed the courtroom. She won the election easily and spent the next 5 years presiding over criminal and civil cases, earning a reputation as a fair and efficient judge. She was then appointed to the Arizona Court of Appeals, where she wrote opinions on everything from contract disputes to constitutional claims. Her prose was clear and unadorned, her reasoning grounded in precedent and common sense. She was not a flashy jurist, but she was a deeply respected one. Yet for all her success, she remained acutely aware of the barriers she had faced. She often reflected on the absurdity of those early job rejections, not with bitterness, but with a kind of weary amusement. The legal world had changed slowly, and she had helped change it simply by refusing to accept its limitations. Her career was a testament to the power of quiet persistence, of doing the work that is in front of you with excellence, and of never letting someone else's narrow vision define your own possibilities. As she sat in her chambers on the Court of Appeals, she could not have known that a phone call from Washington was about to change everything, but she was ready. The Lazy Bee, Stanford, the Senate, the bench, every step had prepared her for what was to come. The summer of 1981 was a season of change in Washington, D.C. The marble corridors of the Supreme Court, usually quiet during the recess, seemed to hum with anticipation. Outside, the Capitol shimmered under a haze of heat, the dome of the Capitol a steadfast silhouette against the bright sky. Inside the White House, President Ronald Reagan was preparing to fulfill a promise he had made during his campaign to appoint the first woman to the highest court in the land. The retirement of Justice Potter Stewart had opened a seat, and Reagan saw an opportunity to make history. His attention turned to a judge from Arizona, a woman whose life story read like a testament to the American West, Sandra Day O'Connor. O'Connor's journey to this moment was anything but ordinary. Born on the Lazy Bee Ranch, she had grown up branding cattle and fixing fences before excelling at Stanford Law School. Yet, despite graduating near the top of her class, she had struggled to find a law firm willing to hire a woman. Undeterred, she carved a path through public service, serving as an assistant attorney general and later as a state senator, where she became the first female majority leader of any state senate. Her judicial temperament, sharpened by years on the Arizona Court of Appeals, revealed a mind that was both rigorous and pragmatic. Reagan, struck by her qualifications and her frontier spirit, saw in her the ideal candidate, a conservative jurist who embodied the American dream. On July 7, 1981, Reagan announced his nomination in the White House briefing room. The room was packed with reporters, the air thick with the click of cameras and the murmur of expectation. O'Connor stood beside the president, her expression composed, her eyes steady. In his remarks, Reagan emphasized that his decision was not based on gender but on merit, calling her a person for all seasons who possessed the qualities of temperament, fairness, and intellectual capacity essential for the court. O'Connor, in her brief statement, acknowledged the weight of the moment, saying she was deeply honored but also aware of the responsibilities that came with the robe. The announcement was broadcast nationwide, and for countless women, It was a signal that the doors of the highest institutions were finally beginning to open. The Senate confirmation hearings in September were a model of civility. In the stately caucus room, with its chandeliers and heavy drapes, O'Connor faced the Judiciary Committee. She answered questions with a calm precision that disarmed even skeptical senators. Her testimony revealed a judicial philosophy grounded in judicial restraint and respect for precedent, but she declined to be pinned down on specific issues, maintaining that a judge must approach each case with an open mind. Democrats and Republicans alike were impressed by her intellect and her unflappable demeanor. The hearings, which could have been a political battleground, instead became a showcase of her qualifications. On September 21st, the full Senate voted. The result was unanimous, 99-0. It was a rare moment of bipartisanship, a recognition that O'Connor's appointment transcended politics. When the news reached her, she was at her home in Arizona, the desert landscape stretching out under a vast blue sky. The phone rang with congratulations, and she accepted them with characteristic modesty. The vote was not just a personal victory, it was a collective acknowledgement that the court should reflect the nation it served. O'Connor's confirmation was a quiet revolution, achieved not through confrontation but through quiet competence and grace. On September 25, 1981, Sandra Day O'Connor took her seat on the Supreme Court bench for the first time. The courtroom, with its soaring columns and red velvet drapery, was filled with dignitaries and family members. As she donned the black robe, the room seemed to hold its breath. Chief Justice Warren Burger administered the oath, and O'Connor's voice was clear and steady. Outside, the autumn light filtered through the high windows, casting long shadows on the marble floor. For the first time in 191 years, a woman's voice would join the deliberations of the nation's highest tribunal. The moment was not lost on those present. Many in the audience wiped away tears, aware that they were witnessing history. In the days that followed, O'Connor received thousands of letters from across the country. Many were from women who saw in her appointment a validation of their own aspirations. Schoolgirls wrote to say they now believed they could become anything they wanted. O'Connor, ever mindful of her role, understood that she carried a symbolic weight beyond her judicial duties. She accepted this burden with the same practical determination she had shown on the ranch, knowing that her work on the court would be the truest measure of her legacy. The public's reception was overwhelmingly positive, a testament to the nation's readiness for change. As she settled into her chambers, surrounded by law books and the quiet hum of the building, Sandra Day O'Connor began the work that would define a generation. The Supreme Court building, with its majestic Corinthian columns and bronze doors, stood as a temple of justice in the heart of Washington. Inside, the chambers were hushed, the air heavy with the scent of old books and polished wood. It was here, in the oak-paneled conference room, that the 9 justices gathered to deliberate the most contentious issues of the day. And for much of her tenure, it was Sandra Day O'Connor who held the balance. Her approach was not one of rigid ideology, but of careful, case-by-case pragmatism. She believed that the law should serve society, not the other way around, and she often sought narrow rulings that could command broad agreement. This made her the court's pivotal swing vote, a role she embraced with a quiet sense of duty. Nowhere was O'Connor's moderate approach more evident than in the 1992 case of Planned Parenthood versus Casey. The case challenged Pennsylvania's abortion restrictions and asked the court to reconsider its landmark decision in Roe v. Wade. The atmosphere outside the courthouse was tense, with demonstrators on both sides holding signs and chanting. Inside, O'Connor, along with Justices Kennedy and Souter, crafted a joint opinion that upheld what they called the essential holding of Roe, a woman's right to choose, while allowing some state regulations. The opinion introduced the undue burden standard, a middle ground that acknowledged the state's interest in protecting potential life without unduly restricting a woman's liberty. In her measured prose, O'Connor emphasized the importance of precedent and the need for the court to maintain its legitimacy. The decision, announced on a gray June morning, was a defining moment that preserved the core of abortion rights while reflecting O'Connor's belief in incremental, fact-based jurisprudence. Her pragmatic touch was also felt in the realm of affirmative action. In the 2003 case Grutter v. Bollinger, the court considered whether the University of Michigan Law School's use of race in admissions was constitutional. The campus in Ann Arbor was a picture of autumn tranquility, leaves turning gold and students hurrying to class, but the stakes were high. O'Connor wrote the majority opinion, holding that the law school's holistic review, which considered race as one factor among many, was permissible under the Equal Protection Clause. Her reasoning was characteristically nuanced. Diversity in higher education was a compelling state interest, but such policies must be time-limited. She famously expressed the expectation that 25 years from then, the use of racial preferences would no longer be necessary. The ruling was a victory for advocates of affirmative action, yet it was also a cautionary note, reflecting O'Connor's insistence that race-conscious measures must be subjected to strict scrutiny and not become permanent fixtures. O'Connor's influence extended deeply into the architecture of American federalism. She was a steadfast guardian of the balance between state and federal power, often siding with states when she believed the federal government had overstepped. In cases like New York v. United States, 1992, and Prince v. United States, 1997, she wrote or joined opinions that struck down federal laws that commandeered state officials to carry out federal programs. Her chambers, with its view of the Capitol, seemed a fitting perch from which to contemplate the delicate dance of dual sovereignty. She saw the 10th Amendment not as a relic, but as a vital check on centralized authority. Her opinions in these areas were not flashy, but they were deeply consequential, reinforcing the principle that the federal government is one of limited, enumerated powers. What set O'Connor apart was her method. She did not issue sweeping proclamations. She built consensus through narrow, fact-bound rulings that left room for future development. In conference, she was known for her practical questions and her focus on the real-world impact of the court's decisions. Her colleagues often remarked on her ability to find common ground, a skill honed during her years in the Arizona legislature. She understood that the court's authority depended on public trust, and she was wary of abrupt shifts in the law that might undermine that trust. This incrementalism frustrated purists on both sides, but it also made her one of the most powerful justices of her era. Yet, her moderate path had its limitations. Critics argued that her case-by-case approach sometimes sacrificed legal clarity for compromise, leaving lower courts and litigants uncertain about the law's direction. Her undue burden standard in abortion, for instance, generated extensive litigation over what constituted an undue burden. Similarly, her affirmative action opinion, while upholding diversity, set a temporal limit that remained aspirational rather than enforceable. O'Connor herself acknowledged the tension between stability and change, but she believed that the common law tradition thrived on gradual evolution. In her view, the court was most effective when it moved cautiously, allowing society to adapt alongside the law. As the years passed, the light in her chambers mellowed with the seasons, and O'Connor's role as the pragmatic center became the defining feature of the court. She was not a justice who sought the spotlight, but her fingerprints were on many of the era's most significant rulings. Her legacy is that of a jurist who navigated the stormy waters of social conflict with a steady hand, always mindful of the human consequences. In the quiet of her office, surrounded by photographs of the Arizona desert and mementos from her days on the ranch, she remained at heart a problem solver, applying the lessons of the frontier to the complexities of the law. Her time on the court was a testament to the power of moderation in an often immoderate world. In the waning days of the 20th century, the soft hum of fluorescent lights filled the corridors of the Supreme Court building, where marble pillars stood silent beneath a dome of muted gold. Outside, the Capitol was caught in an unseasonable chill, the bare branches of cherry trees tracing delicate shadows on the pavement. Inside, Justice Sandra Day O'Connor sat in her chambers, surrounded by stacks of briefs, the weight of an unprecedented election dispute pressing upon her. The presidential race between George W. Bush and Al Gore had come down to a razor-thin margin in Florida, and the nation's eyes were fixed on the court, waiting to see if it would intervene in the recount process. O'Connor, ever the pragmatist, understood the gravity of the moment. The quiet order of her daily life, morning walks with her husband, the familiar rustle of legal papers now gave way to a case that would define the court's relationship with American democracy. The dispute had its roots in the chaotic Florida vote, where hanging chads and confusing ballots led to weeks of legal battles. After the Florida Supreme Court ordered a statewide manual recount, the Bush campaign appealed to the U.S. Supreme Court, arguing that the lack of uniform standards violated the Equal Protection Clause. On December 9th, the court issued a stay, halting the recount. O'Connor, who had been attending an evening party when the news broke, reportedly expressed dismay that the stay had been granted, a hint of the internal tensions to come. Days later, the justices convened for oral arguments. The courtroom, with its rich mahogany benches and heavy red drapes, felt more hushed than usual as lawyers presented their cases. O'Connor listened intently, her questions sharp but measured, probing the practical implications of allowing the recount to proceed under varied county standards. When the decision was handed down on December 12th, the nation learned that the court had ruled 7-2 that the recount as ordered was unconstitutional, and by a 5-4 vote that no constitutionally valid recount could be completed in time. O'Connor joined the majority in the per curiam opinion, which held that the Florida court's recount scheme lacked uniform standards for evaluating ballots, thus violating the equal protection rights of voters. The remedy was to end the recount, effectively securing Bush's victory. For O'Connor, the decision was a painful exercise in judicial restraint. She believed the court had to act to prevent a constitutional crisis, even as she privately worried about the institutional cost. In the days that followed, the marble halls of the court seemed to echo with the criticism of scholars and citizens who felt the justices had overreached. O'Connor's role in the case was complex. She had reportedly wanted to retire under a Republican president, and some observers noted that her questions during oral arguments suggested skepticism toward the Gore team's position. Yet her approach, as always, was grounded in a case-by-case analysis, not partisan loyalty. She focused on the practical impossibility of crafting a uniform recount standard in the hours remaining before the Electoral College deadline. The majority opinion emphasized that its consideration was limited to the present circumstances, a hallmark of O'Connor's narrow, fact-bound jurisprudence. Still, the decision left a deep scar on the public's perception of the court. The building's Greek Revival exterior, usually a symbol of enduring justice, now seemed to some a fortress of political power. In the years that followed, O'Connor rarely spoke publicly about Bush versus Gore, but those close to her reported that she harbored misgivings about the case's impact on judicial credibility. She had always championed the court as an institution above politics, and the 5-4 split along ideological lines troubled her. In quiet moments, perhaps sitting in her Arizona adobe home, watching the desert light fade over the mountains, she reflected on the delicate balance between resolving a national crisis and preserving the court's legitimacy. The decision, she came to believe, had damaged the public's trust, a wound that would take decades to heal. Her pragmatic instincts had guided her to a solution, but the lesson she drew was that even the most careful judicial reasoning cannot always shield an institution from the perception of partisanship. Despite the controversy, O'Connor's conduct during those tense weeks revealed her deep commitment to the rule of law. She worked tirelessly, poring over precedents and discussing the case with her clerks in the soft glow of her desk lamp. The process reminded her of her days on the Arizona bench, where she had learned that justice is not an abstract ideal, but a daily practice of listening, weighing, and deciding. The Bush versus Gore experience underscored for her the importance of civic understanding. If the public could not grasp the court's reasoning, the institution's authority would erode. This realization would later fuel her passion for education, but in the immediate aftermath, it left her with a sober appreciation of the court's fragility. Today, the Supreme Court building still stands as a temple of justice, its bronze doors depicting historic scenes of law. But for many, the shadow of Bush versus Gore lingers in those halls, reminder that even the most revered institutions can become entangled in the raw politics of the moment. O'Connor's legacy in the case is that of a justice who sought a pragmatic exit from a constitutional thicket, even at great personal and institutional cost. Her willingness to act, and her later reflection on the consequences, offers a lesson in humility, that the law, for all its majesty, is wielded by fallible humans, and that its power must be exercised with an ever-watchful eye on the trust it requires. In the soft light of a January morning in 2006, the Supreme Court building stood quiet, its grand chambers soon to lose a familiar presence. Justice Sandra Day O'Connor, after nearly a quarter-century on the bench, had made the difficult decision to retire. The reason was deeply personal. Her beloved husband, John, was battling Alzheimer's disease, and she needed to care for him. As she packed her office, the shelves lined with law books and mementos from a lifetime of service, she felt the pull of duty in a new direction. The marble corridors, which had witnessed her pragmatic rulings and steady temperament, now echoed with the footsteps of a woman stepping away from the pinnacle of judicial power to embrace the role of caregiver. It was a choice that reflected the same self-reliance she had learned as a girl on the Lazy Bee Ranch, where family and responsibility came first. O'Connor's retirement was not an ending but a transition. She and John returned to Arizona, settling into a modest home with a view of the desert she loved. The rhythm of their days slowed, morning coffee on the patio, walks among the saguaros, and the quiet companionship of a long marriage. But even as she tended to John, her mind remained active, troubled by a growing crisis she had observed from the bench, a widespread ignorance of how American government works. She often recalled the confusion she saw in the public's reaction to court decisions, a gap in understanding that threatened the very foundation of democracy. With the same pragmatism that defined her jurisprudence, she resolved to address this civic deficit, not through lectures or books, but through an innovative, hands-on approach that would reach young people where they were. In 2009, O'Connor founded iCivics, a nonprofit organization dedicated to revitalizing civic education through free, interactive online games and lesson plans. She envisioned a digital platform where students could step into the roles of lawmakers, judges, and activists, learning by doing. The project was a departure from her judicial work, yet it drew on the same skills, breaking down complex problems into manageable parts and building consensus. From a small office filled with educators and game designers, she championed the cause with characteristic energy, often testing the games herself. The early titles, like Do I Have a Right and Win the White House, transformed dry civics into engaging challenges. O'Connor believed that if young people could experience the workings of government firsthand, they would grow into informed, participatory citizens. The impact of iCivics was swift and profound. Within a few years, millions of students across the country were using the platform, and research showed significant gains in civic knowledge. O'Connor traveled tirelessly to promote the program, speaking at schools and conferences with a warmth that belied her former judicial reserve. In classrooms, she would watch children navigate virtual courtrooms, their faces lit by computer screens, and see the spark of understanding. The work gave her a new purpose after the quiet sorrow of John's decline. He passed away in 2009, and she channeled her grief into the mission. The desert landscape around her home, with its stark beauty and enduring resilience, mirrored her own journey, a reminder that even in arid soil, life could flourish with care and intention. In recognition of her extraordinary contributions, President Barack Obama awarded O'Connor the Presidential Medal of Freedom in 2009, the nation's highest civilian honor. The ceremony in the East Room of the White House was a moment of national gratitude, as colleagues and family gathered to celebrate a life of firsts and service. O'Connor, standing beneath the crystal chandeliers, accepted the medal with characteristic humility, deflecting praise to the importance of the civic mission. She saw the award not as a capstone but as a platform to amplify her message. The event underscored her legacy as a trailblazer who had shattered the Supreme Court's glass ceiling and then dedicated her retirement to strengthening the democratic fabric she had sworn to uphold. As the years passed, O'Connor herself faced the shadows of dementia, the same cruel disease that had taken her husband. In 2018, she announced her withdrawal from public life, a quiet retreat to the Arizona desert where she could live out her days in peace. Yet even in seclusion, her influence endured. iCivics continued to grow, reaching over half of all middle and high school students in America. The lessons she imparted of pragmatic problem-solving, respectful dialogue, and the necessity of understanding one's government remained embedded in the digital tools she created. Her final years were spent in the care of family, surrounded by the rustic adobe walls and the soft, slanting light of the Southwest, a fitting end for a woman who had always found strength in the land and in service. Sandra Day O'Connor's legacy is not confined to the annals of the Supreme Court. It lives in the millions of young minds she touched through iCivics, in the model of balanced, constructive public service she embodied, and in the quiet dignity with which she faced personal trials. From the lazy bee to the highest court, and finally to a classroom of the future, her life was a testament to the power of pragmatic idealism. As the desert sunsets over her beloved Arizona, casting long shadows across the mesas, her story remains a gentle, enduring lesson that the work of justice and democracy is never finished, but it is always worth doing, one generation at a time.